Welcome everyone to the second webinar of this special series on alcohol policy in Canadian municipalities. My name is Tina and I will be introducing today's session. The topic of today's webinar is a legal framework for developing a municipal alcohol policy. So I would now like to introduce our two presenters for today's session. Robert Solomon has been involved in legal research on alcohol regulation and the development of related public health initiatives, civil liability, impaired driving law, and criminal law for over 50 years. He has served as a consultant on these issues to Health and Welfare Canada, the Law Reform Commission of Canada, the Canadian Centre on Substance Use, and provincial and territorial liquor licensing boards across Canada. Professor Solomon was involved in the research, development, and delivery of the first sets of municipal alcohol policy programs in Ontario, British Columbia, and Nova Scotia. He has expertise in the role of law in promoting public health, has prepared 2 legal briefs and research articles on duty to warn and legal liability for fetal alcohol spectrum disorder, and has formerly been the National Director of Legal Policy for MAD Canada. Secondly, Elyse. Elyse Kim is a second-year law student at the University of Victoria with a strong interest in health law. Her work involves performing legal research and analysis of legal liability, most recently on the topics of fetal alcohol spectrum disorder and municipal alcohol policy. Elyse holds a master's degree in philosophy, where she concentrated on theories of justice with a particular focus on advancing the well-being of marginalized individuals and communities. Drawing on the expertise from her philosophy background, as well as her legal studies, Elyse is dedicated to mobilizing knowledge to reduce alcohol-related harms and improve public health outcomes in Canadian communities. Thank you both for being here.
Thank you, Tina.
Thank you.
So before I hand over to Robert, just a quick note about the objectives for the presentation today. So by the end of this session, participants will be able to understand the sources of general trends in Canadian municipal law, appreciate how municipal alcohol policy fits within the governing provincial liquor acts and provincial municipal acts, identify and find the licensing and municipal legislation that applies in their community, identify key legislative powers that municipalities can use to implement community-wide alcohol policies, and finally, develop a decision tree for implementing a comprehensive municipal alcohol policy in their community. I will now hand over to Robert to get us started.
Thank you very much, Tina, and thank you for all your support and feedback over the course of producing this webinar. You sort of stole a little bit of our thunder in terms of my preliminary issues that I want to discuss. Elyse and I had 2 goals in preparing this document. The first was to situate municipal alcohol policies within the context of Canadian constitutional law, and more specifically, provincial legislative authority. Our second goal is to provide a general framework for developing municipal alcohol policies, rather than definitive answers on specific municipal alcohol issues in any one jurisdiction. As Elyse will discuss, there is more than one municipal statute in most provinces, and they are all exceedingly long and complicated. We did not attempt to review all the acts in all the jurisdictions on each issue. Rather, we've drawn examples primarily from Ontario, British Columbia, and to a lesser extent, some other provinces. Nevertheless, the framework which we have presented is broadly applicable to the development of municipal alcohol policies in all of the provinces, as well as in all of the territories. Now, our PowerPoints are not very pointy, as I'm frequently criticized, but we have also provided riveting endnotes to the document to illustrate the statements in the text. Full citations to the provincial, municipal, and liquor legislation is provided in Appendix A and Appendix B. And the cases and secondary materials also include citations in the endnotes. Now, we hope that providing this level of detail will provide participants with a sufficient written record to pursue policy development in their local municipality. Elyse will lead the discussion in the first half of the substantive slides, and I will lead the discussion in the last half of the substantive slides. We will pause from time to time to field questions and comments that have been put into the chat. I will now hand the floor over to my wonderful co-author, who has chosen to move from London to the other side of Canada. So please take it away, Elyse.
Thank you, Professor Solomon. Okay, so just so everybody knows, there is a table of contents that might be helpful later on if anybody is trying to make their way through these slides. Okay, so the starting place for municipal law and sort of all law in Canada is the Constitution. The Constitution Act of 1867 delegates power to the federal and provincial governments. So at the time that the Constitution was created, approximately 80% of Canadians lived in rural communities. So the need for municipal power was in some ways less pronounced. But since then, things have changed, and about 70% of Canadians now live in urban environments, leading to an increase in the need for municipal powers. That said, it is still the case that municipalities have no independent constitutional status or power. The provinces use their constitutional power over property and civil rights to create municipalities. They do this through various pieces of legislation that create and define the responsibilities and corresponding powers of municipalities. In a 1993 Supreme Court of Canada decision called R and Greenbaum, the court explicitly stated that municipalities have no independent power aside from what is explicitly granted to them by the provinces. It is therefore the case that any powers municipalities have can be found in their governing provincial legislation. So we have created a list of all of that legislation, and it can be found in Appendix A of this presentation. All right. So the structure of municipalities is not the same in every province. Some provinces, such as Saskatchewan, have different pieces of legislation depending on the size and location of the municipality. Other provinces, such as PEI, govern all municipalities through one single piece of legislation. In Ontario, the Municipal Act applies to every Ontarian municipality except Toronto, which is governed by its own piece of legislation called the Toronto Act. And in BC, Vancouver is similarly governed by its own piece of legislation, while the remaining municipalities are governed by two pieces of legislation, the Community Charter and the Local Government Act. So this is all to say that the powers of municipalities may range even within a single province. Increasingly, we see city-specific municipal legislation for large urban centers, such as is the case in Toronto, Vancouver, Winnipeg, St. John's, and Calgary. Now we're going to look at some trends in municipal legislation. First, although municipalities still have no independent constitutional status, their powers have begun to expand. But the extent to which these powers have expanded tends to vary from province to province. Second, most provinces have revised their municipal acts since the 1990s, and it has become increasingly popular to adopt city-specific charters for larger cities, as we've seen in Toronto, Vancouver, Winnipeg, Calgary, and St. John's. Third, it used to be the case that provincial legislation would give municipalities specific enumerated powers, and they would interpret these powers very narrowly. The more recent legislative trend involves giving municipalities broad authority over specified matters. But what that means is that court challenges are likely going to be involved in pinning down the exact scope of these broad powers. Fourth, the courts have also recognized the fact that municipalities are best situated to deal with certain matters, leading to them to become more deferential in their approach when deciding if a municipality has acted within their power. This expansion of municipal powers is likely to be a good thing for municipal alcohol policy. But as the authors of a really helpful review have said, municipal law in Canada is in a state of transition. So this sometimes makes it difficult to draw hard rules from the legislation and case law. So just as the provinces create legislation governing municipalities, they also create legislation governing liquor consumption and sales. The provinces have extensive authority when it comes to alcohol. It covers everything from how alcohol is produced, distributed, marketed, advertised, and taxed, as well as the wholesale and retail markets within their boundaries. Provincial authority also reaches into the everyday realities of how alcohol is used, from who can hold a license, when and where alcohol can be served, how it can be transported, what it costs, and under which conditions it can be consumed. The provinces have used these powers to create a comprehensive regulatory framework for liquor serving establishments. Virtually all aspects of the liquor industry and related hospitality sector are governed in some way by provincial law. While the provinces could, in theory, delegate some of this authority to municipalities to allow these municipalities to adapt liquor laws that reflect their local health and safety priorities, they have generally not taken that step. So we have provided a detailed breakdown of the various provincial liquor control legislation, and it can be found in Appendix B of this presentation. So here is just a flow chart that illustrates the different levels of legislation that apply to alcohol policy. So at the top, we have the Constitution, which creates both federal and provincial powers. From provincial powers, we get the various municipal acts and liquor control legislation. And it is within this legislative framework that municipal alcohol policy is created. So, as many of you likely know, municipal alcohol policies are not a new thing. They've been around for some time. Municipalities started developing alcohol policies in the 1980s when it became clear that they could be sued if alcohol-related harm happened on their property or through events they licensed. Scholars have looked at municipal alcohol policy from many different angles, including legal liability, ways to reduce risks, how to bring municipalities into the policy process, and how to judge whether policies are effective. Given that these powers delegated to municipalities have been expanding, there's been significant success for municipalities in implementing these sort of traditional alcohol policies. Encouraging municipalities to implement these traditional alcohol policies is one really important piece of the puzzle. But we will be shifting the focus from property-specific measures to asking whether municipalities can play a role in shaping alcohol use at the population level, outside of just their buildings and parks. As we've seen, given that the provinces have enacted a fairly comprehensive legislative scheme for the regulation of alcohol, it is inevitable that any municipal bylaws aimed at regulating alcohol will overlap with the provincial legislation. Overlap, in and of itself, does not render those bylaws inoperative. Rather, overlap will only be an issue if the overlapping municipal bylaw conflicts with the provincial legislation. In those cases, the bylaw would be rendered inoperative to the extent of the conflict with the provincial legislation. Assessing what constitutes a conflict is therefore really important because it will largely dictate where and how municipalities can act in the area of alcohol policy. That said, the test for what constitutes a conflict is not necessarily straightforward, as the provinces have not adopted a uniform approach. So, this issue of overlapping legislation and what constitutes a conflict turns on the specific province at issue and how they do or don't define a conflict. So, in British Columbia, for example, in order to determine whether a bylaw conflicts with the provincial legislation, BC uses a test called the impossibility of dual compliance test. It's fairly straightforward and looks at whether it would be possible to comply with both the municipal bylaw without contravening the provincial legislation. The title is rather informative. It has to be possible to comply with both laws. And Ontario uses a two-part test that in some ways is more restrictive than that of BC's. So the first part of the test is the same as BC, impossibility of dual compliance. But the second part of the Ontario test looks at whether the bylaw would frustrate the purpose of the provincial legislation. This second part of the test is a bit more difficult to pin down as it depends on how the courts interpret the purpose of the relevant provincial legislation. Since that purpose is not always clearly stated in the legislation, the outcome of a court's analysis of the purpose of the legislation is in some ways difficult to predict. As such, there's arguably a higher likelihood of a bylaw being struck down in Ontario, as would be the case in a province governed solely by the impossibility of dual compliance test. So we know BC uses impossibility of dual compliance, Ontario uses impossibility of dual compliance and frustration of purpose. And we also know that the Supreme Court has held that in the absence of a specified test, the default test is that of impossibility of dual compliance. That said, we have not reviewed the test for overlapping legislation in every single province. So, as Professor Solomon has mentioned, municipal legislation tends to be very long and complicated. So, just to illustrate that, in BC alone, the Community Charter and Local Government Act comprise over 1,000 sections, which interact with numerous regulations. So it wasn't possible for us to conduct a definitive analysis for each and every province. And now I'd just like to pause for some questions. If the municipal bylaw was more strict than the provincial regulation, would this be a conflict? Example, provincial minimum price of 150 and the bylaw requiring $2 minimum price. This might not be a conflict in BC, but may likely be a conflict in Ontario due to frustration. Yes, exactly. So in BC, if the provincial minimum was $1.50 and the municipality wanted to enact minimum pricing that was more restrictive, they generally will be allowed to do so under the impossibility of dual compliance test, just because it would be possible to comply with the $1.50 minimum price by enacting a minimum price of $2. But as you've mentioned, in Ontario, there might be a conflict in that scenario if the courts determined that the Ontario legislation was meant to cover the entire field of pricing. So in that way, a higher minimum price may frustrate the purpose of the provincial legislation.
Question in the Q&A is, does other substance use policy, for example, illicit substances, have the same legal framework, or is it developed, overseen differently?
I would, sorry, Professor, did you want to go first?
In terms of illicit drug policy, you'd have to factor in the federal criminal law. So that would take priority. The federal government has exclusive control over criminal law and criminal procedure. And so you'd have to add on a layer in terms of what is the current federal criminal legislation. And that would indicate how much room, if any, was left to the provinces. and in turn, how much room was left to the municipalities?
In the way that the provinces create legislation regulating alcohol, I don't think it would be the same legislative framework for other illicit substances. So, as Professor Solomon has mentioned, it would likely be the criminal code would be a large part of the analysis there. If the municipal alcohol policy is increasing health more than the provincial one, would that allow the municipal regulation to stay? The test is sort of the same, which would be the impossibility of dual compliance. So in some ways, the bylaw may be more beneficial in terms of health, but it would still have to meet the test of impossibility of dual compliance.
Yeah, I think whether or not the the proposed municipal bylaw would better advance the interests of public health is not the issue. This is about whether or not there's legislative authority. And I agree with Elyse, the same test would apply. Even if the municipal legislation or proposed bylaw was far more prudent from a healthcare or public health perspective.
So I will hand it over to you, Professor. There we go.
Uh, Thank you. Thank you very much. So what I'm going to do is I'm going to begin to look at what the actual municipal powers have exist. And the first of those powers is what is called a general welfare power. All of the provinces have granted to municipalities a general welfare, the power to enact bylaws for the general welfare. And they are framed often in slightly different terms. So in Saskatchewan, this general welfare powers is framed in terms of the right to enact bylaws for the quote, safety, health, and welfare of people and the protection of people and property. In Manitoba, the power is framed in basically very similar terms. Now, when you first look at this general welfare power, the municipalities can enact bylaws for the safety, health, and welfare of people and the protection of people and property. It doesn't seem like there's much else that they can't do. But these broadly worded general provisions although they appear to give ostensible authority to enact municipal bylaws that would include population level liquor control measures, you have to look at these general provisions in the context of the rest of the Municipal Act. So, for example, the municipal public health bylaws in British Columbia have to be approved by the responsible minister or be in accordance with the ministerial regulation or agreement. Now, nothing stops a municipality in British Columbia from seeking the necessary ministerial approval for a broad range of health-related alcohol measures. So I guess the point that is important to emphasize is despite the broad wording of the general welfare provisions, it has to be read in the context of the rest of the legislation. Now, although I didn't include this on the slide, it's also important to emphasize that in addition to the general welfare power, the municipal acts contain equally open-ended provisions authorizing the enactment of bylaws on a range of issues. For example, the Manitoba Municipal Act grants municipalities authority to enact bylaws relating to, among other things, roads, highways, local transit, public lands, days and hours of business that businesses may operate, activities, people, and things in or near public places, and businesses, business activities, and persons engaged in business. However, these broad powers must be exercised, quote, for municipal purposes. The Manitoba Act then goes on to define municipal purposes, but not in a way that sheds any light on how it's to be interpreted. So I think the difficulty is in these areas is that the legislation appears to give ostensibly very broad authority to municipalities to control or to enact population level bylaws affecting alcohol, but they are limited by the legislation, other provisions in the legislation, and a great deal more research has to be done in each of these areas to determine how the courts have interpreted these specific powers. Okay, municipal planning power. Although different terms are used, municipalities have authority to develop and adopt long-term plans for land use management. In British Columbia and Saskatchewan, these documents are called the Official Community Plan, while in Alberta, they're called the Municipal Development Plan. Now, a municipality's ability to regulate alcohol pursuing to the municipal planning power is subject to provincial oversight in each jurisdiction. In half the provinces, such as Ontario, Saskatchewan, and New Brunswick, the plan must be approved by the province. In the remainder of the provinces, such as Alberta, Nova Scotia, and Manitoba, the plan must comply with the governing municipal act and regulation. So while municipalities have the ability to create municipal plans, they are still subject to the authority of the province. Once a municipality adopts a community plan or development plan, all zoning bylaws must comply with it. Now, the planning power can and has been used to preclude alcohol outlets in specific areas, such as those set aside for residential development, schools, or open spaces. However, the opposite is true. For example, to be designated as a large urban village under Victoria's official community plan, a neighborhood must include a liquor store and a full-service pub. So the municipal planning power ostensibly provides authority to control alcohol in various ways, but it has to be approved by the province. Again, the municipalities don't seem to have independent authority to enact planning documents independent of provincial approval. So once there is an official plan, then you must look at the zoning power. Municipalities can use zoning bylaws to preclude the establishment of liquor outlets in areas that are exclusively set aside for residential, industrial, and other non-commercial or non-retail purposes. Zoning bylaws can also be used on a more granular level to regulate alcohol outlets, even in areas designated for commercial, retail, or mixed-use development. So bylaws could likely be enacted to limit late-night hours, number and size of licensed venues in the vicinity of hospitals, care facilities, and residential properties. Bylaws can be enacted to prohibit nightclubs, casinos, liquor stores, and certain other types of licensed venues from being established within a specified distance from a public school or place of worship. And bylaws of this kind have been enacted in a number of jurisdictions. However, the zoning bylaw must be grounded in a legitimate planning purpose, such as addressing incompatibilities with land use, traffic, parking, noise, vandalism issues, demands on police services, and sanitation and safety concerns. So there is the power to use municipal bylaws to limit and control licensed outlets, but this must be exercised for a legitimate planning purpose. In my view, or in our view, a zoning bylaw enacted simply for the purposes of encouraging responsible alcohol use would likely be challenged for failing to serve a legitimate planning purpose.
We just have a few clarifying questions that pertain
Sure.
to this slide. So, is approval a requirement also for the territories? For plans, that is. So, for official community plans.
Uh, Unfortunately, we haven't researched that issue, so we would have to look at the legislation in the specific territory to see if the legislation uh, 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 includes a statutory test of what a conflict is. If it doesn't include a statutory test of what a conflict is, then the impossibility of dual compliance would apply. So we basically haven't researched that issue. If you would like to contact us and give us the name of the territory, we could look into it and perhaps provide an answer.
To clarify, would a zoning bylaw be part of the municipal development plan?
Um, as I understand it, the municipal development plan provides the broad framework, and then zoning bylaws are enacted pursuant to that broader plan.
That's how I understand it too. As a comment, perhaps a way forward is for municipalities to start/continue seeking approval from responsible ministers on a range of matters. It is my perception that many municipalities aren't aware of their powers that apply beyond the control over property.
That is one way to proceed, and I think that's important. So municipalities have, at least on paper, very broad powers. They're subject in many cases to provincial oversight. So municipalities should be pushing the provinces to grant them more authority. Unfortunately, we have seen in a number of jurisdictions that the provincial government is not prioritizing alcohol policies that promote public health. So the difficulty may rise at the political level, that there's no political interest at the provincial level to support policies that limit the availability of alcohol. Another thing that municipalities can do is that they can use their broad powers, enact bylaws, and see if they're challenged. Nothing stops the municipalities from pushing the envelope. Unfortunately, what happens is the provinces makes the money and the municipality picks up the pieces in terms of costs, primarily and frequently in terms of costs in terms of police and other resources. So I think it's a good idea for municipalities to approach the province and see if the province would give consent to or give them authority to enact population level alcohol policies. And in addition, municipalities should feel free to enact population level controls over alcohol to address local needs, and then see if they're challenged. And in many cases, they will be.
Regarding welfare provisions for the protection of property, is the definition of property applicable to revenues or profits from corporate/economic entities, or is it mostly about physical property?
I believe from my reading that it's about physical property. It's about tangible property, real property, as opposed to things like profits. That's my understanding of how the municipal acts are defined.
That's my understanding as well.
And the reason for that, municipalities are given separate authority in terms of taxing. So it would be incongruous, at least to me, that the definition of property in the general welfare bylaw would apply to things like profits and revenues.
Would a zoning bylaw for the purpose of restricting exposure to alcohol from youth fall under a safety concern? So, alcohol vendors would have a restricted proximity to places where youth gather, such as schools, daycares, and youth centers.
As I understand it, that has already been done in some jurisdictions. Is that correct, Elyse?
That is correct. We have a citation for a bylaw in Calgary as well as Fredericton, where they have enacted bylaws for the exact reason that.
Yeah, and I think, saying there can be no a liquor outlet within or licensed venue within X number of feet of a public school, etc. There could probably also be limits in terms of municipal enacted signage requirements, both prohibitions on public advertising, as well as municipalities requiring licensed outlets to have various kind of signage. The one issue in terms of signage is that depending on how the signage bylaw is drafted, there may be an issue with the Constitution, namely freedom of expression. Um, but we'll leave that aside. So yes, they could limit by distance the outlets, and they could also probably impose some limits in terms of advertising, subject to constitutional limits under the charter. Is that your understanding, Elyse?
That is also my understanding. You described that municipalities must deposit public health related bylaws with the minister in BC. What would be the legal view of what constitutes a public health related bylaw? The BC Public Health Bylaws regulation describes it as a bylaw in relation to the protection, promotion, or preservation of the health of individuals. Does this mean that it must be the municipal intention to address health, or can external judgment be made as to whether the bylaw affects public health?
I'm not sure I understand the nuances of the question. Um, uh, the way in which the general welfare bylaw is written, it would seem to encompass both measures that directly impact health or which have, a impact on health. That's at least that's the wording of the general welfare. So it could be things like limiting uh, days and hours that licensed establishments could be open, which would have a direct impact on population health, as well as things on signage, which have or advertising, which have a more indirect impact on public health. So that's my understanding, that it would include both uh, uh, things which have a direct impact on availability and access, as well as those things which have a proven indirect impact. That's my understanding. I'd have to look at the exact wording of the bylaw to determine, um, uh, whether or not that would be the case.
And just to add to that, so in BC, there actually is, within the enumerated powers of municipalities, they have a separate power for public health related bylaws. And then, in a very sort of convoluted way, within the regulations, they then restrict that power by stating that any bylaws enacted pursuant to this public health power do require that ministerial approval. But in other provinces where it's not sort of segmented in terms of health versus public health, I think that what Professor Solomon has described very is accurate, true.
I think one of the key points that is coming out is that it's very difficult to come up with a definitive answer on a general issue. Because the legislation is different in every province, and the test of what constitutes a conflict is different. In Ontario, it's a test that limits municipalities based on legislative intent, and it's quite clear that talking in the abstract about how a court will interpret legislative intent is not for the faint-hearted. And so, I think one of the things that Elyse and I were reluctant to do is to give definitive answers to general questions, because we were worried if somewhere in a particular, municipal act in a particular province, there wasn't buried in one of the regulations something that would render our answer incorrect. And that's why we've focused on providing a framework rather than attempting to give definitive answers. I mean, there's some areas in which we can, and we've tried to, and we've illustrated that in the footnotes and in the text. But in other areas, we have been reluctant for fear that without further research, we would be misdirecting or misguiding people. Okay. Municipality, okay, we're going to talk about municipal taxing powers. Municipalities are only permitted to impose taxes when the province has explicitly authorized them to do so. And typically, but not always, the municipal taxing power is limited to taxes on real property. Some provinces have given municipalities additional taxing powers. So, for example, municipalities in Alberta are authorized to impose a business tax based on annual rental value of a property, the assessed property value, and other variables. Municipalities can designate the classes of businesses to which such taxes apply, and presumably this includes licensed establishments. So it would seem that, at least in Alberta, municipalities have considerable authority to impose business taxes on licensed establishments. Toronto appears to have the power to impose a sales tax in addition to harmonized sales tax on a person purchasing liquor. And when you look up that provision, what the provision says is Toronto has no authority to impose sales tax. And then it lists a whole bunch of exceptions, and one of the exceptions in which they are not prohibited from imposing a sales tax is on a person purchasing liquor. And this is typical of the legislation, namely that there will be a provision and then a long list of exceptions to that provision. Municipal power to impose business licensing fees. Municipalities have authority to impose business licensing fees, but oftentimes the licensing fee will be challenged on the basis that, in fact, it is a tax, which exceeds the municipality's legal authority. Now, the general distinction is that a licensing fee relates to the cost of a particular municipal service, such as policing or public health, etc. So a tax isn't geared to the actual expenditures or costs imposed by a municipality, whereas a licensing fee is contingent upon a particular service or is related to or commensurate with the cost that that business imposes on the municipality. So Red Deer enacted a bylaw that included a business licensing fee on drinking establishments. In upholding the licensing fee, which increased with the size of the establishment, the court emphasized that the fee was consistent with the city's broad powers and additional costs of policing. Similarly, Vancouver imposed an annual licensing fee on drinking venues based on their maximum capacity. And again, the argument would be that licensed establishments pose additional costs on the municipality in terms of policing, public health, fire regulation, sanitation, noise, enforcement of noise bylaws, etc. So there's considerable power to impose business licensing fees, but they have to be related to some additional cost to the municipality.
Can municipalities implement a tax on alcohol to fund enforcement or community sports, for example? So I think that that would be related maybe more to licensing fees where they could cite evidence for some sort of cost.
Yes, but the first half, what was the second half of your question? I mean, could they use it to pick up the additional enforcement costs? Absolutely.
Yes.
Could they use that as a means of funding sports activities? No. Again, it wouldn't be geared to the cost that the business is imposing upon the city. And again, I think the point that the commenter just made indicates that you have to look at the specific municipality. Vancouver is governed by a separate municipal legislation, as opposed to all of the other jurisdictions, which are governed by the two acts that Elyse mentioned previously. Now, in addition to imposing business licensing fees, municipalities have the power to enact business licensing bylaws. So we've distinguished between the fees that they can impose and bylaws relating to other things. So municipalities have the power to impose conditions on the business licenses that they issue unless a provincial legislation provides otherwise. So, for example, Ontario expressly prohibits municipalities from including any condition on the sale or service of liquor in a business licensing bylaw. However, this would not prevent Ontario municipalities from imposing conditions on licensed venues under their zoning or other powers. Even in the absence of an express prohibition, as exists in Ontario, if a business bylaw conflicts with a provincial law, it will be struck down. Okay, so Ontario prohibits any condition on the sale of liquor in its business licensing bylaws. In other jurisdictions, there may be no prohibition, but if the business licensing bylaw conflicts with the provincial legislation, the business licensing bylaw will be struck down. However, as Elyse explained, what constitutes a conflict differs from province to province. And we've attempted to provide an example. Municipalities governed by the impossibility of a dual compliance test may have considerable leeway in regulating licensed facilities. For example, pursuant to this test, no conflict would arise between a municipality's $3 minimum drink price and a provincial $2 minimum drink price. Licensed venues could comply with both provisions by charging a minimum of $3. Analogous overlap situations may arise regarding, among other things, municipal requirements regarding signage, staff training, security, outdoor patios, liability insurance, and municipal limits on the size, location, and operating hours of licensed establishments. So as Elyse has explained, because of the broad control the provinces have over alcohol, you're going to have many, many circumstances in which there's an overlap. And so the issue then becomes, is this a conflict? And then you have to find the test for how a conflict is defined. Okay, so we've provided a decision tree in the next slide, Elyse. So if you look, and the decision tree is not as elaborate as it might be. So under the Municipal Act, what you would do is look to the general powers provision of the Municipal Act. Okay, and we haven't laid that out in this and then look to the Liquor License Act. If there is no overlap between the power given to the municipality and the Liquor Act, hey, no harm, no foul, no overlap, municipality can enact the bylaw. But in most circumstances, you are going to have an overlap between the municipality's general powers and authority and the very comprehensive provisions of the liquor license legislation. And so the question is, once there is an overlap, how does that jurisdiction define conflict? If there's no conflict, then the municipality can enact the bylaw. If there is a conflict, then there would be no power to enact the bylaw. So the decision tree, you look at the general powers or the powers given to the municipalities. There's usually a section of the Municipal Act dealing with municipal authority. You look at the provisions of the liquor license legislation. If there's no overlap, municipality can enact. In most cases, there will be an overlap because of the comprehensive nature of the provincial liquor legislation. You've got to figure out and find the definition of conflict. If there's no conflict, they can. If there's a conflict, they can't. Municipalities have long had largely unfettered power to control alcohol-related activities and events occurring on municipally owned property and premises. This is the low-hanging fruit in terms of municipal alcohol policy. As a first step, municipalities should take full advantage of this power to ensure that all such activities and events are consistent with public health principles for minimizing alcohol-related harms. And the good thing in terms of the municipal alcohol policies, the traditional ones that govern municipally owned and operated premises, is there's been a great deal of work that's already been done on model policies for municipally owned property and premises. So this should be a first step, and there is excellent models of the kinds of things that municipalities can do. Research on this started in the 80s, and there are model policies that have been developed. Now, moving away from municipal policies related to municipal property and premises, the recent trends favor the enactment of municipal alcohol bylaws that extend to the broader community. So what we've seen is there has been a tendency to review the municipal legislation, give municipalities broader general powers. And we've also seen the courts have tended to adopt a more liberal or broader interpretation of municipal powers. So the trend is going the right way. Nevertheless, determining whether a municipality has the power to enact a specific alcohol-related bylaw turns on the wording of the bylaw, the governing provincial liquor legislation and municipal acts, and the definition of what constitutes a conflict. Okay. In closing, I think Elyse and I want to note there were several other broad, promising areas that we didn't have an opportunity to review, such as municipal control over the local police resources and priorities, and municipal input on the granting of liquor licenses and special occasion permits. So these are other broad areas where municipalities could exercise control. So for example, nothing stops a municipality from having uniformed police officers walk through licensed establishments at 10:30 Thursday, Friday, and Saturday night to make sure that people aren't being overserved. Nothing stops them because they control local police resources. Nothing stops a municipality from having a last drink program, where if the police are required to break up a fight, or if police pick up someone at 2 o'clock in the morning, they inquire, where were they drinking? And this information is passed on to the local liquor license inspector, who might visit the venue, which is responsible. So these are broad additional areas that we did not have an opportunity to research. All right, let's open up the floor for questions.